Good morning, Mr. Parrish. How do you pronounce
I
Fanuc?
pronounce it Fanuc, but I could be wrong.
Fanuc. All right, I'll go with that. That sounds great.
I don't see Ms. Klein yet, so with the court's
Okay.
indulgence, I'll wait.
Yeah, we'll give it a, she's going to join us here right now.
I hand it.
Morning, Ms. Klein.
Good
How are
morning.
you? Okay, so Mr. Parrish, do you want to reserve 5?
I'd like to reserve 6 if that's not too much trouble.
Well, 5 is the max. So
Okay. Okay, then I'll
we're only
reserve
going to
5.
get 5. Okay. All right. So we're ready whenever you are.
All right, thank you. So good morning, may it please the court. Philip Parrish on behalf of the appellants, William Fanuc and Kathy Kelly as the personal representative of the estate of Dylan Gonzalez. This is an appeal from a summary judgment here on de novo review. The defendant moved for, and the trial court granted that summary judgment based solely upon an argument that Mrs. Reyes did not see actual consumption, did not have knowledge of actual consumption because she was not physically present and in her condominium at the time. In so ruling, the trial court rewrote the statute because the statute says on 3 separate occasions that you have to have knowledge of consumption or possession or consumption. And there is record evidence that.
So help me with the knowledge of possession that she had.
All right.
I know you make the case that there was liquor left in the condo and therefore that's possession. Is that really what we're talking about here? I mean, you think the legislature meant that anytime a minor is in any residence where there's alcohol in the residence, that minor is in possession of that alcohol?
Well, when you have in this case, when you have a minor who has both a driving under the influence conviction and a boating under the influence conviction and is 20 years old and has a friend over staying the weekend, and you know this son of yours drinks liquor, you leave the...
Well, except for while he was on probation, he was tested routinely and all those tests came back negative. So he had a current recent track record of not drinking. And the corollary to that argument is a lot of people would say, here this young fella has had a driving alcohol issue and a boating alcohol issue. Certainly he's got it, right? I mean, we parents are optimistic about our children.
Or maybe he has a real problem and without significant treatment, he doesn't really have it under control.
I'm sorry, Mr. Parrish, I'm having a hard time understanding that argument on possession. Is it really your argument that a minor's proclivity to drink changes the law's definition of what constitutes possession? Because we know that mere presence of something even in the vicinity does not amount to possession, much less a person's knowledge of possession. So help me out with that gap.
Well, I disagree that he was in control. He was the only person. He and his friend were the only persons in the condo at the time. They had access to. There's evidence that they knew where it was. They went and got it, and they poured drinks for the 3 young ladies.
So by the lights of that argument, then, if his mom had kept OxyContin in a medicine cabinet in that condo, then by the lights of your argument, he would be guilty of being in possession of OxyContin without a prescription.
Well,
right? Because it's there.
I haven't looked into the law on what it would take to convict someone of possession.
I'm just going by possession. Your argument is that he was in possession of the alcohol and that for purposes of the statute, Ms. Reyes knew he was in possession of the alcohol. Your argument earlier to Judge Morris was that, well, the alcohol was there in the condo, therefore he had access to it, therefore he possessed it. I have a big question about that the underlying premise of that notion, because it doesn't seem to square with how the law has historically defined possession, even temporary possession, much less the next step of the argument, which is that the mother had knowledge of this.
No. Again, because the motion was drafted solely on the basis of consumption, the record wasn't developed as to what possession means. The legislature did not define it in the statute. Possession can mean that you have the ability to dominate or control the substance, which he in fact did here. So I don't know why this would not constitute possession in an undefined statute, which is directed at trying to make certain that underage minors do not possess or consume. If the statute had only wanted to control consumption, it would have said only consumption. It also
Don't you think that statute, though, is intended to prescribe parents who think it's okay for minors to drink in their presence, sort of a thing? In other words, that they have a role in making the alcohol available to be possessed or to be drank. Not that they incidentally have alcohol in their residences. And if they go out for a movie, presumptively they have acquiesced to that, to their minors possessing alcohol illegally. I mean, that just doesn't sound like the legislature intended what you're arguing.
Well, so the legislature included, Your Honor, basically a negligence standard here. And a backstop for all of this is that the jury determines whether the parent in this case has taken reasonable steps to prevent possession or consumption of the alcoholic beverage or drug. It doesn't say dispossess or take it away. It says prevent the possession. There's a backstop here for a jury. All we're asking is that.
Well, in this case, we know that one of the reasons this young man chose to live with his father instead of his mother, because his mother had strict rules that he didn't want to abide by. And some of those rules were articulated in the briefing, that the mother, he wasn't allowed to have friends over without her permission. He wasn't allowed to drink, obviously, with her. I mean, she was a pretty tough character. And when she showed up from a night out on a date, she was angry that there were people in the condo and told them all to leave.
That is correct. She did tell them to leave, but she left her son and his friend in the possession of the condominium where alcohol was there, and there's evidence that it was in plain sight and easy to get to. That the son, Dalton, asked the young ladies, "Can I pour you a drink?" Poured them shots of vodka.
So the message to parents of teenagers is you need to lock your alcohol up in a safe.
Well, in fact, she did in her permanent residence. She didn't do it here in the condominium.
Right, but by your argument, every parent will now have to put the proverbial padlock on the liquor cabinet, or else if two kids get together and help themselves to the tequila,
what kids will do,
which kids will do. Don't get me wrong, but they will be held liable under the statute because of that. I mean, is that the argument you're making?
If they know the kids are there alone, and if the kids then go out and injure someone,
Assume that for purposes of ascribing liability under the statute, if the kids consume the alcohol and go out and hurt somebody, parents are per se liable unless they put a lock on the liquor cabinet.
If a jury determines that they hadn't taken reasonable steps, the jury should determine whether it's a reasonable step under the circumstances of each particular case as to whether there was a lock put on it. I mean, they could take into account the fact that she put a lock on the private residence, the permanent residence, and didn't hear as perhaps she knew that she should have and didn't for whatever reason and didn't.
You're not totally disclaiming the notion, though, that the lock becomes kind of a mandatory feature, which is
it doesn't.
Which is a strange notion of being knowledge of another's possession.
The facts of this case are tragic. They are heartbreaking facts.
Yeah.
They're totally tragic. I mean, and I understand, the effort to want to hold everybody accountable who can possibly be held accountable. And I guess the question we have to figure out here is, how far does a parent's liability extend, particularly on these facts?
Well, and I would say my argument, Your Honors, is that that's not your call, that is the call for a jury under this statute to determine whether the parent took reasonable steps. The statute already, it doesn't say a parent who owns, it says a parent who, it says control means authority or ability to regulate, direct, or dominate. So the fact that the mother's not present isn't an issue, because she had the ability to direct, and she had the ability. She didn't say when she left, there's alcohol there. I know how much is in it, and if there's any, missing. When I come back, you're gonna have heck to pay for that. She just left, went out for the evening, and left her son, who had a history of alcohol abuse, in the apartment with his friend. And then we know what happened. They 3 other young ladies showed up. They drank. They got in a boat. He was speeding, hit a channel marker, and then killed one of our clients and seriously injured another. So,
I mean,
But
this is
are
a
the
very
facts
tragic
really in
case.
dispute here? I mean,
Mr. Parrish, why aren't we dealing with an improper pyramid of inferences? Because you've got to establish an open house party first. And it's a very vague definition, means a social gathering at a residence. And it appears, and I'm not making a ruling, but it appears that it's designed for parents who are either hosting or know that there's going to be a social gathering of minors. Now, we know from the record that she testified, Ms. Reyes testified, that he was not allowed to consume alcohol in the condo. She testified to that. She didn't permit it, and he didn't drink alcohol in her presence.
I
You hear me?
just caught the beginning of that question, Judge Sleet. I think you were asking that you made a statement. It appears that it was designed to for people who are hosting known parties, and I would suggest that it doesn't appear that way.
But it clearly, I got to take the plain language, because it says allow.
I agree.
You may not allow. Now, there's no indication. She testified that she knew Taylor and her son Dalton were going to drink, because they didn't have her permission to drink. There's only 2 people there. I'm not so sure that 2 persons make a house party or make a social gathering yet, but she needs to know that the alcohol is in their possession. There's no indication when she left that they possessed alcohol, intended to possess alcohol, because they certainly didn't have her permission. So when she leaves, that is the state of affairs. And when she comes back, she sees that it's different, and she puts a stop to it, which could be considered a reasonable step to prevent. So you're talking about the gap in between. Do we have a social gathering that fits the definition for an open house party first? Just because he's in the condo alone doesn't impute liability to the mom that he's going to go get drunk, or he's going to take a Yeti and fill it full of vodka all day. She had no knowledge of that. I'm sorry, but you couldn't get that out of her. And none of the other kids said anything either. And it's not like when she came home, did she ever make any statements like, I told you not to have a party. I knew you were going to do this. You don't have that either. So where's the duty?
Well, first of all, Your Honor, open house party is defined as a social gathering at a residence.
Is that 2 people?
Yes, Your Honor, it can be. The statute does not say it isn't. We cited to you the Michigan statute, which actually does define it as 2 or more people, so long as
We have our own statute.
Which I was going to
Michigan
say,
said 2 or more people. We haven't.
I think that Michigan statute might actually cut against you, right? Because it evidences that when a legislature wants to make it a 2 people make it a gathering, they can define it in such a way. But here's the thing: there's a canon of statutory construction that says that words that have an ordinary meaning, we use the old term used to be man on the street or the person on the street kind of standard of what those ordinary terms meaning. Gathering in the English language does not usually mean a couple. I mean, if I were to talk to somebody and say, hey, look at that gathering of children playing over there, and pointed to 2 kids, they'd probably look at me kind of funny, right?
Well, 2 responses to that, Your Honor. First, that argument was not raised below, and therefore cannot be the basis of the summary judgment. Second, 2 or more can be a gathering. We just pointed out that another state defined it that way. The fact that Florida didn't define it one way or the other doesn't mean that it can't be.
Right. Well, it suggests to me that the use of the word gathering, the Michigan legislature apprehended that term would not capture what they wanted it to, because the term does not mean what they intended it to. And so therefore they included a specific definition to say, hey, this word gathering in this context shall mean 2 or more people. Florida's
Mr. Parrish,
legislature
you're at
didn't
14
choose to
minutes,
include
just so
that.
you know.
All right. I'll save the remainder of my time for rebuttal then. Oh, but I got one more.
No, you got 1 more minute. So you better
So
use
just to
it.
answer your question, Judge Lucas, So is three enough? I mean, what kind of mischief can you get into with three that you can't get into with two? It's still a small gathering. It's a gathering. It's there. There's no definition in the statute, and other states have used two or more. And what they're trying to get at is that you don't want underage minors drinking in the house or possessing the alcohol.
Well, I don't think the statute sweeps that broadly. The statute proscribes allowing house parties.
For 15 minutes, just so everybody knows.
Right. I'll save the remainder of my time for rebuttal then.
Okay. Ms. Klein?
Good morning, Hinda Klein, on behalf of Monica Reyes.
Ms. Klein, can I ask you a question right off the bat? At
Yes.
summary judgment, were there disputed issues of material fact, or did everybody kind of agree what happened here?
I think that they agreed to what happened here. There really
Okay.
aren't any disputed factual issues to be determined by a jury.
Well, let me ask this question, Ms. Klein, then, if that's the case, because I was looking very closely at the testimony about the mother when she arrived home at around 3:30 a.m. There was testimony that she was visibly upset, and she admonished Dalton either in front of them or took him away to another room. But then there was other testimony that she didn't talk to him at all. And then her testimony was, I don't remember anything. Is that a genuine issue of material fact as to whether she knew what was occurring or not?
No,
Okay.
because first of all, it is not clear from any of the testimony that any of these individuals were drinking at the time that she arrived home. A lot of what occurred happened hours beforehand. So if she came home and saw a number of strangers there, that doesn't give rise to actual knowledge that these individuals were consuming alcohol on the premises. So even, looking at the facts in a light, most advantageous to the plaintiff here, without that actual knowledge, there simply is no viable claim here. There is no question of fact regarding the possession of alcohol before Monica left for the evening. I believe that the panel understands that even if, for the sake of argument, the two individuals who were at the condo could constitute an open house party itself, and even giving some credence to the argument that if those individuals are there alone, that necessarily gives rise to at least the implicit possession of alcohol that was there. Here, the undisputed facts show that at no time before Monica left for the evening, while she had possession of whatever alcohol might have been there, did any of these individuals drink. And since the statute requires actual knowledge, not constructive knowledge, not the anticipation of knowledge, but actual knowledge, the question becomes whether at the time Monica left the premises, she knew that Dalton had possession of alcohol or consumed alcohol, and she did nothing. And there is literally no issue of fact on that point. Everybody who testified who would know testified that there was no alcohol consumption before Monica left. And I would posit that there could be no alcohol possession of something that was in Monica's possession while she was at the premises. So there is no genuine issue of material fact sufficient for a jury. And as we argued in our brief, there's certainly no requirement in the statute, implicit or explicit, that a parent of a minor child have the responsibility to padlock alcohol. And as we pointed out, the gun statute does have that requirement. I think if the legislature intended to require families with minor children to lock up their alcohol, they would have said as much. And therefore, I don't think that this is an issue of fact sufficient for jury consideration. It's simply not something that can be read into the statute, and there's simply no genuine issue of material fact in this case that would give rise to a jury question and that would render the summary judgment inappropriate or incorrect. So if the court has no further questions, I would respectfully rest on my brief and request that the court affirm the summary judgment.
Well, it does
Thank you,
look
Ms.
like the
Klein.
court in its oral findings found, and I'm looking at supplemental record 47. The definition of gathering is an assembly or meeting, especially of a social or festive one held for a specific purpose. I don't think you can say that the two boys there for a weekend was a social, thus an open house party. So it does look like the court addressed it, raised it. It was raised below. Is the court correct, Ms. Klein?
Personally, I think that the court was, especially when you look to the language of the statute, which uses the term open house party. That seems to me to require that there be something more than two friends sitting around watching TV. I'm not really sure why the definition is as broad as it is, but it's clear from the context of the statute that that was not what the legislature intended. I think that if they had, they certainly wouldn't have used the phrase open house party. They could have just used the term house gathering or gathering at a residence or something. But I don't believe that that this is within the contemplation of the legislature, which is why, frankly, we didn't address it in our motion for summary judgment, nor did we take issue with it in our answer brief, because it ultimately wasn't the grounds on which the court granted summary judgment. But because Your Honor asked me, I think that, in fact, that was a legitimate argument to be made, and certainly one that would not give rise to a question of fact in any event. So it wouldn't change the fact that opposing counsel is obliged to bring forth genuine issues of material fact that would be appropriate for a jury's consideration.
Thank you.
Anything further, Ms. Klein?
No, Your Honor. Thank you.
Okay, thank you very much. Mr. Parrish, you have 5
Yes,
minutes.
I believe that Ms. Klein just conceded that the trial court granted summary judgment on a basis that she did not move for summary judgment upon. And Judge Morris in the HSBC versus Mullen case, and there's other authority from this and other courts, that you cannot grant summary judgment on the basis of something that wasn't argued. The entire motion for summary judgment was based on lack of knowledge of consumption. And that was, we agree, she was not there at the time. We don't have evidence that she was aware when they were drinking her alcohol that they were drinking her alcohol. That's not the case. Our argument has been that the statute references possession or consumption, and therefore, if it was knowledge merely of consumption, they're entitled to summary judgment. But
Well, the argument was that the statute basically would allow for summary judgment in this case, and to nitpick it like you have, I don't think is what we've contemplated.
Judge, Your Honor, on page 227 of the record, everything, they never say possession. The word possession doesn't appear, I don't believe, in their entire motion. It says consumption. Now, in terms of social gathering, it's not defined by the statute. There's no reason why a gathering of two people is not a gathering. They were there for social purposes.
Well, because the ordinary common man isn't going to think of social gathering as being two people. And the legislature chose those terms, and we have to give them their ordinary and plain meaning. And I don't think you'll find anybody who will say that a social gathering includes 2 people. You won't. Most people don't think of it that way. So
I think.
we can't look beyond the words. We have to give them their plain and ordinary meaning, and we're bound to that.
Okay. I respectfully disagree, but I understand what the panel has said today. I think that, again, the final backstop in this statute is that in order to be held liable, first of all, there has to be a death or serious injury. Second of all, a jury has to find that reasonable steps were not taken to prevent the possession or consumption. So let the jury decide whether they believe that that this is a situation where liability should be imposed, and it should not have been a summary judgment. We would ask the court to reverse and remand.
Okay. Thank you very much. Thank you both. This is a very sad but intriguing case from a legal standpoint. And you both have done a great job in trying to help us figure it out. Thank you. Have a good day.